so last week I presented on the Nell Potgieter case. And there's more to it. So I'm going to unpack it further today. Because there's always layers to the stuff. And a great part of my work is to create the awareness of the many forms of abuse that actually overlap and intersect with maintenance matters. And it's important to understand that, because if people do not understand the abuse, then you're just dealing with bits and pieces of paper and files, and they're just going to be moved around. And the family courts, unlike most of the other courts, is emotional. And part of our challenge is that the family courts all operate in silos. And I might have said this last week, but if I haven't, I'm going to say it now, is that there should be duplicates of every bit of information that is happening in a different court, because it is only through that you actually get an understanding of the complexities and the urgency of cases. So if you have a case going on in children's court, and you have a case going on in the family court and in the domestic violence court, and it culminates in you having to approach the maintenance court for immediate relief, and if there is no perspective, the maintenance officer is going to look at it one-dimensionally and make a ruling that will not protect the victims. And the sad part is that the primary caregiver, who is normally the mother, is also a victim. But the Maintenance Act is premised on the protection of the child. But the child does not have a voice in the maintenance courts, and it therefore depends on its primary caregiver in the majority vulnerable, marginalized people who are women. And again, with the diversity in this country, we have women. We have white women who have inherent privilege, and then all the way down to black women who have always been marginalized and are still marginalized and still do not have the voice. So while our Act allows for all of this variance, as women in the space, and when we speak up, we need to be cognizant when we speak on behalf of women. And we should always speak and think from the position of the most vulnerable of society. And it's important to understand this, because I'm now going to start speaking about the background stuff with the Potgieter case, Potgieter now. And part of the prejudice and the harm is the lengthy processes to finalize maintenance cases with a fair and equitable agreement. And that is the space that the financial abuse accelerates and compounds and causes more harm. And I'm speaking through the divorce lens initially because they got divorced, they were married. But from here on, for most of the stuff, it applies to anybody accessing the maintenance courts. So just to recap, Potgieter was found guilty in the maintenance criminal trial for not adhering to a court order issued in 2012 and incarcerated for 4.5 years in 2018. He appealed the sentence, lost his appeal in August 2021, and is now serving his sentence. That was the original timeline. What I have done is I've now highlighted, just to give you an idea of the different people and the different things that were at play. So if you look at the purple, 2009 is when he served divorce papers. And then if you look at the next purple on the timeline, it's 3rd of August 2012, when the divorce was granted. And then if you look at the last one, 12th of August 2021 is when he lost his appeal. So you can see between the two purples how much litigation took place that had very little to do, in fact, didn't have anything to do with maintenance, the maintenance court. And then there was the bulk of the maintenance litigation happened between 2012 and 2018. And you'll see now how many days that was. So if you just look at the different colors, the yellow is applications for protection orders by Potgieter. And not a single one of them were upheld. Every single one of them were dismissed. That speaks to coercive, controlling, and manipulating behavior, using the court as a tool to cause further harm. The pink is Nell's one application in this time, and that was to apply for protection or Rule 43. I'll cover that a bit later on. The grey is Potgieter's malicious behavior to limit her access to finances. And that's part of the behavior to prevent the other person from having equitable representation through the litigation process. Because if the one person runs out of the financial means, they're immediately at a disadvantage. The yellow ones, the green ones, are all the times that she was arrested and spent time in jail as a result of the protection orders. A lot of the time she was arrested in front of her children. The one occasion she was driven off the road for an arrest to take place by a metro policeman who happened to be a relative. These are all intimidation tactics. And we hear women tell their stories that they can't tell in a maintenance court because those belong in a domestic violence court. But if the perpetrator is intentional and strategic about it, he is always one step ahead. And you are always, as the victim, you are always being reactive. And what impact does that have on a victim? You're constantly having the wind punched out, and then you have to recover, and you're hardly recovered when you receive another blow, which eventually wears down the emotional capacity to think rationally and to stand up courageously to carry on fighting. And it's therein that women give up. And it's understandable. And where we come in as a support is to encourage them, to hear them, to acknowledge them, to validate their feelings so that they can carry on. Approximately 33 appearances between May 2009 and January 2013, excluding maintenance court, all of which are not on the above timeline. A clear case of vexatious litigation, which constitutes constructive financial abuse. 365 days from 2009 to 2015 in various maintenance courts. That's how much time Louise Nell spent in maintenance courts. She lost a year of her life. And she was trying to have her and her children's rights to maintenance enforced. she was awarded rehabilitative maintenance. In Section 28 of the Constitution, every child has a right to family or parental care. How could she care for her children when her hands were cut off financially? How could she care for her children when she could not warm food up for them? How could she protect her children and provide for them if she could not even provide the basics of water and food for her children? To basic nutrition, shelter, basic health care and social services, to be protected from maltreatment, neglect, abuse or degradation. On that same timeline, these are the only things, other than the ones on the extreme right, that actually had anything to do with maintenance. Those are Nell's files. For all the other litigation as well as her maintenance files. One person's. You can imagine how much energy and effort it actually took her to have to deal. If she's provided that much paper, it gives you an indication of how much litigation she actually went through. And there's more to be added to that, and that's probably not all of it anyway. What should have happened? So Potgieter served divorce papers on Nell in May 2009. After a couple of months, it became apparent that he wasn't going to contribute anything financially, so Nell approached the maintenance courts. They were awarded an interim maintenance order. He didn't comply with that, and then an attorney advised Nell to take out a Rule 43, which she did at a huge cost, because that was still the early stages. She still had some finances. Now, non-compliance of a Rule 43 would have been remedied through the maintenance court in any event. And in fact, the interim order made by the maintenance court was the exact same order sanctioned by the High Court in the Rule 43. Section 10.6a, a maintenance court shall conclude maintenance inquiries as speedily as possible and shall ensure that postponements are limited in number and in duration. If procedure and processes had been followed as prescribed in the Maintenance Act, there would have been a very different outcome, much different to what Nell experienced. So this is what should have happened if the maintenance courts were acting in the best interest of the child and adhering to procedure and interpreting, implementing and enforcing the Maintenance Act as it should have. So Potgieter serves divorce papers. He doesn't contribute financially, so now applies for an interim maintenance order, which is granted. He defaults on the maintenance order, so you'll notice the purple is Potgieter, the white is the court, and the pink is Nell. Show variants thereof. So he defaults on the maintenance interim order. So in January, Nell could have approached the maintenance court and lodged a non-compliance. In January, that's being gracious. 3 months later, they should have appeared in court. In April, Potgieter agrees to pay the arrears and adhere to the maintenance agreement by agreed timeframes. Okay, this is hypothetical. But this is just another tactic It's taking that into account. He has no intention of adhering to it. So it's making allowances for the coercive, controlling, and manipulating and intimidating behavior. So he doesn't comply to that. So again, in the July, just 3-4 months later, now could have approached the courts to lodge another non-compliance application. Court issues a J306 and Potgieter is informed to appear in court in the October 2010. Just be mindful of these time frames. October 2010, they appear in court. Again, Potgieter promises to pay after being informed he will face criminal prosecution. January now reports non-compliance of maintenance order. The court issues an attachment order in January 2011 because now there's a history of non-compliance and his behavior. And the court go, okay, we've actually had enough. So now we're going to issue an attachment order. So the court issues an attachment order on Potgieter's personal bank account to freeze his bank account. Because up until this point, with all the other litigation, he has excluded her from the joint bank accounts. He has managed to wrestle the joint company away from her. And in between all of this, sold it to his new fiancée. So all they could really attach is his personal bank account for the arrears. Potgieter applies for a suspension of the attachment order in March 2011 because we've seen this, he has a habit of appealing everything. In June 2011, the suspension is denied and Nell has paid out the arrears from his bank account. So we're down to 2 years and she's got money. Compare that to the first timeline, where she was still in the thick of litigation and now run out of money. In August 2012, the divorces grant is finalized. Again, in November 2012, Nell reports non-compliance of maintenance order. And then the criminal trial would start in 2013 as opposed to 2015 on the previous timeline. And 3 months later, he's found guilty. In July 2014, giving him just over a year's grace for the appeal, he lost his appeal and goes to prison. That would have been July 2014. Whereas on the previous timeline, it was only concluded, well, he lost his appeal in 2021. The emphasis here is on the timeline. So if the maintenance courts worked as purposed, you can see one now would have been in a completely different position, not just financially, but emotionally and psychologically as well. Because she would have felt supported by the maintenance courts. Her children would actually have been protected. But she was thrown to the wolves. So why was the previous hypothetical ideal not realized? The lack of training. Nell was never guided by any of the maintenance court staff as to what recourse was available as stipulated in the Maintenance Act 99 of 1998. She relied on Google. She asked friends for advice. She used common sense in what she thought she should do next. But she never gave up. She felt unsupported and never felt there was any urgency to assist her and her children. And the interpretation, implementation, and enforcement was not coherent. The lack of understanding of the domestic violence, particularly coercive, controlling, and manipulating behavior, contributed to the lengthy time it took. because his behavior just changed post-relationship, and his playground became the courts. So his behavior changed shape and form using money. Lack of training in understanding and being able to recognize abusive behavior, which plays itself out in the maintenance court. Postponements caused irreparable harm to Nell and her children in multiple ways. The abuse is silent, but no less violent, which impacts not only on the victim, but society at large. Because when Nell was arrested, she would phone a friend. When Nell was homeless, she had to ask somebody to take her in. When Nell lost her car, she had to ask somebody to pick up her kids. And this is the impact that it has on society at large. Differently, but it happens. So it's not just the victim that is impacted. And take this times 50 in one tiny community, and you can understand the levels of anxiety, depression, post-traumatic stress disorder that people are living with in community. Oops. What happened there? So I worked out an estimated cost to Nell through the negligence of the maintenance courts. So I worked out at approximately 1,500 Rand per day that she spent in court. And that is conservative for what Nell's earning was at the time of the start of litigation, which came to 547,000 Rand. That's what it cost her just being in court for 365 days, plus transport, plus printing, and I just put a figure there of 3,000 Rand, just for the sake of realistic numbers. So that's what it costs now to approach the maintenance court. These are unhidden costs that are never taken into account, that contributes to the financial and economic vulnerability of a person who is already desperate, who is approaching the courts for immediate help. But they are further abused by the system and compromise that just makes the vulnerability greater. And the maintenance courts is there to prevent this, yet it's the cause of more harm. So if we just extend that a little bit further and look at some real costs. Sorry, I just want to get my phone because in the transfer of the files, I've lost a whole lot of information there. And this is what it costs now. The lengthy periods of litigation and where it harmed her instead of protecting her. She lost her motor car. She drove a top-of-the-range Mercedes-Benz, and when she met Potgieter, she owned the property. She owned a car. She owned a business. He arrived with 2 suitcases. Okay? So she lost her Mercedes-Benz, valued 500,000 Rand. She lost her house, which from the time that they got married and they upscaled, because he wasn't working, he started working for her. Yes, he did contribute, but he upscaled. And when they bought a new house, he convinced her to give him half to register the house half in his name. They were married in antenuptial. Okay? So she lost her house. 3 million Rand for the house. She lost all of her furniture because she had no money and she had to move around. R500,000 it cost her to store the furniture when she had to leave the matrimonial home and to move it around in different provinces several times, and then eventually sold it off just to be able to keep living. She lost her retirement, which is approximately 5 million rand. Medical cover, approximately 300,000 rand over that time period. She lost over 9 million rand, over and above the 500,000 rand that it cost her accessing justice. Does any of that make sense to any single person? And I use this as a very public case, and I use this just to show how dramatic the impacts are of non-compliance of maintenance officers and magistrates in the maintenance court. And this impact is exactly the same for every single other person accessing the maintenance courts, at some level or the other. So, what do we hope that the maintenance officers, maintenance investigators, magistrates, court managers, anybody who works for the Department of Justice realizes from this? That they are in violation of not just the mother, but more so the child's constitutional rights. Every single time. It's impossible for us all to take the stuff on review and appeal. But this is a system that is built. It's become an amazing industry. And it doesn't stop in maintenance, it spills over into co-parenting. Because if he can't punish you enough financially, he will eventually say, you cannot look after the child and the child now needs to come and live with me. And the ultimate punishment for a mother who has carried a child and looked after it as a primary caregiver is to remove the child from her care. Unjustly. It's a crisis. And I know a lot of people think that I'm dramatic. This is based on reality. I'm not making this stuff up. And it's incumbent on legal practitioners to understand this. How can you protect your clients if you do not understand the abusive behavior? How do you protect your clients if you accept postponements and just keep communicating with his legal representative and racking up bills that 90% of the cases that the applicant has borrowed money for? And in the end, not many even go to court with their legal representative because they've run out of funds. And even then, they still do not get a fair amount of maintenance. And they never ever recover what they've lost. And this is the grey area of from the start of the application until the end. Everybody has control over this grey area. There's a start and a finish. And the people who are there to protect the most vulnerable of society, paid or unpaid, you are obligated to protect. So I developed a scale of financial abuse because all of this is abuse through money, which is financial abuse. Just to put it into context, there's an international scale of economic abuse. And as I've said before, economic abuse takes place in relationship. Financial abuse is how it changes shape and form post-relationship because money is the tool. So if you can answer yes, if somebody going through the maintenance court, how many of these can you answer yes to? Do you have a court-ordered maintenance agreement? Is money immediately cut off when the relationship, rephrase it, was money immediately cut off when the relationship ended? The father has the financial means to pay but refuses. The father said, you must go to court and he will pay child support. Sorry, the father said, do not go to court and then I will pay child support. And then when you don't go to court, he doesn't pay child support. The father deliberately caused or causes postponements. The father pays for children or a child that is not yours, his new partner's child. The father does not pay the amount stipulated on the court order. So if it's 1,000 Rand, 1 month he'll give you 900 Rand, the next month he'll give you 500 Rand, and the next month he might give you the full amount again. The father does not notify you when he will not be able to pay as required. The father blocked you from communicating after you asked him a couple of times when you're going to get your maintenance. The child support percentage is not proportionate to income. The father hired a lawyer to fight for less maintenance. The father stopped paying child support when he met a new partner. The father refused to pay an amount. Instead, he said he will buy what the child needs. The father demands slips for all money spent on the child. The father transferred assets out of his name to reduce the value of his assets in arrears claims. The father claims unemployment and earns cash to avoid a record of his income. The father deliberately resigned from his employment to avoid paying child support. You have to remind him to pay child support. Okay, so what I want you to realize about all of these things is, one, it's to keep you in a state of anxiety. He'll pay, but when it suits him, and that is the control aspect. He controls the money. He has the power. We see this. How many court dates, your maintenance orders are normally payable by the end of the month. Then the court still says you've got 7 days. So he knows he doesn't have to comply with the court order, but he can pay on the 6th day. But guess what's happened up at that point? Your debit orders are bounced. You get a bad credit rating. That speaks to economic abuse because it limits your economic opportunities. Go for a job interview, you're blacklisted. You can't get credit. So if you do manage to get back on your feet and you want to buy a house, because research shows us that the father still lives in the matrimonial home or similar. The mother has moved in with family or friends. And it's far more common than we like to believe, because women, because of the insecurity, they cannot get a place of their own, especially if there's no maintenance agreement in place. Especially if you come out of a relationship and you weren't working, you've got to provide 3 months bank statements. So this is the vulnerability of women and children. So it's the behavior here. It's using the money, as subtle as what it is, by paying on unpredicted dates. That keeps the victim in a perpetual state of anxiety. How am I going to feed my kids? They needed to go on a school outing. I am short. I don't get financial support. I borrowed money and I promised at the end of the month, or as soon as my court order is granted, I'm going to court in a week's time. I'm going to definitely get a maintenance order then. It doesn't happen. You fail to pay the money back. Next month, you're in the same situation. Who are you going to borrow from? Because now the story's gone around. I don't lend her money because she doesn't pay it back. Can you say this in court? Do they understand when you go, I am absolutely vulnerable. I cannot take another postponement. I've got a loan shark that I'm now borrowing money from, and they're going to break my legs. Or they're going to kidnap my children, because they don't care. They just want their money back at a completely inflated interest rate. These are all compounded things that impact on the most vulnerable of society. And then we speak about protecting them. That's what the Maintenance Act is supposed to do. And I believe that every single person who goes to the maintenance court should actually fill in one of these forms. It's how we're going to change. It's how we're going to educate. It's how we're going to create awareness of patterns of abuse. I'm not going to go through this again. This is from last month. But what I do want to emphasize is non-negotiable rights. Human dignity, equality, and children. And when a woman is fighting like Nell did, where is the equality? Where is the dignity? And where were the children protected? The preamble of the Maintenance Act says, to establish a society based on demographic values, social and economic justice, equality, and fundamental human rights to improve, not make worse, the quality of life of all citizens, and to free the potential of all persons by every means possible, including, amongst others, by the establishment of a fair and equitable maintenance system. Nothing equitable about our maintenance system at the moment. Section 10.6a, again, postponements limited in number and in duration, and concluded as speedily as possible. And if we look at the now time frame, from what it was to what it could have been, we can see why. It needs to be limited in duration. This is Louise Nell's message to the DOJ. The department is failing women and children. The system does not protect those seeking help. Many women's lives are falling apart, and the staff are indifferent and unhelpful, and delays and exasperates the vulnerability. Nell and her children were homeless and suffering, yet the court did not see it as urgent. They do not explain the process, and the courts are overwhelmed. The staff need training urgently in order to realize the purpose of the Maintenance Act and protect the most vulnerable, who are women and children. Sorry, this is Nell's message to mothers going through the system. Join support groups and become knowledgeable. Ask for clarity. Do not expect to get it from the maintenance courts. We've heard this. Advocate Mohammed said the same thing. Make copies of everything. If you can't get copies, take photos and save it and print it and put it in your files. Keep records of every single thing. Take names of people that you speak to. Complain to management if you are not happy with the way that your case is being handled. Follow up on your cases. Be courteous to the people at the court. Don't give up. You will encourage others to push through, and your children do not have a voice in the maintenance courts. They depend on you to be their voice. DOJ needs to fix this broken system. We cannot protect women, irrespective of how amazing a GBV NSP is. Not paying financial support or not getting is a form of domestic violence. Sadly, it is not mainstream enough, but it's up to us as well to keep speaking about it being a form of financial abuse. And at the same time, trying to educate every single stakeholder who works with children, with women, with vulnerability, with policy, in equity, in job creation. It has such far-reaching impacts. And it's up to all of us to start learning more about it and advocating. The Domestic Violence Act Amendment Act is supposed to come into law next month. Maintenance is mentioned several times in that, but we know what's going to happen. Because there is no training, it's there because it's a form of domestic violence. But you go to the domestic violence court and just mention maintenance, and they go, sorry, you need to go to the maintenance court. because they're all operating in silos. But the biggest thing is, so the law says we're going to go, yippee, let's go and do this, but they are not trained. And you're going to be turned away from the domestic violence courts. And if that happens, you need to document it, you need to complain through us, because we have strategies that we are going to be tackling this. And again, it speaks to the consistency is lack of training. And the compound lack of training has on the most vulnerable. And I just wish that we could do a, what's the word? All of us get together. No, that also, lots of those. No, we burn down Parliament. No! A class action. Thank you all. I just had to find it. I wish that we could have a class action about maintenance, but we can't because it's too nuanced. There's too many different factors. But we need to have a class action of sorts. 1, 2, we need to set a precedent about constructive financial abuse, because that will change the game. Because just like with Mohammed Singh, the courts will be scathing. And we need to have a summit.
In the revised Domestic Violence Act, they're now making provision for protection orders for financial abuse. How do you think that's going to make a difference?
It's not.
In the case of Nell in Portugal, she was arrested several times for violation of protection order. So the abusive mom has a protection order for financial abuse, and he violates my mom's pay. You can have him arrested.
Okay, so you can't get a protection order for financial abuse because there's no such legal definition. You can get a protection order for economic abuse. You can get a protection order after June for not adhering to interim maintenance. But you will be lucky in the first place if you get an interim maintenance order in the domestic violence court. 1. 2, I have a protection order for economic abuse. And then I couldn't, when I first went, they did not want to have him arrested. I had to take my investigating officer to the domestic violence court to have him educated. It's a whole long story. I don't have the time to go into it now. He was eventually arrested, and then it was beautiful. We sat around the boardroom table with the chief prosecutor, and we ended up singing Kumbaya together. His warrant of arrest was withdrawn, and he went clapping because half the arrears was written off. And we did. And I reduced my maintenance by 13,000 rand. Just to get rid of him, just to stop this process. Long story forward, he's been in violation 4 times since then. The second time I went back, they refused to issue a warrant of arrest. They told me to go to maintenance court. I reported SAPS because I was abused at SAPS. I reported SAPS. They were investigated. They were found not guilty. In fact, that's not quite concluded because I escalated. 3 years on, I'm still waiting for a report from Western Province Head. I reported the 2 magistrates, and nothing has been done. Nothing. They've never come back to me because they stuck with their thing that this is a maintenance court issue. And let me just explain this. This is not a cent is for me. It's to protect my neurodiverse child who needs protection for the rest of his life. So it's not even for me. That's how they care for the marginalized and the vulnerable. And that is my concern of what is going to happen with the provisions in the amendments, because nobody is trained. Nobody understands this. But we need to report that, and we will train, and we will keep fighting. It's going to take time, but we have to insist on this. Thank you.